Hogan briefs the judge on the findings of the XRP Army's investigations. Judge Netburn likely keeps tabs on some XRP enthusiasts via Twitter. I didn't buy it at first, but now I do. Judge Netburn, I can finally see you. Judge Sarah Netburn has until after September 28 to issue her ruling on the privilege issue. The SEC Ripple dispute took a big turn yesterday. The judge was clearly seeking explanation regarding the SEC's assertions of the deliberative process privilege DPP and the XRP, and the XRP holders had filled the conference room as promised. Earlier claim that the agency's internal materials were crucial to the fair notice case were ignored. The judge and George Tonariro, who is an attorney for the SEC, debated the objectiveness versus the subjectivity of recklessness. Is recklessness an objective or subjective criterion? She asked Mr. Tonariro, in response to the straightforward question. There was considerable avoidance, a lawyer named Jeremy Hogan said in front of a camera. To start with, Judge, let me just first start off by saying, but eventually, even the SEC had to acknowledge that the criteria was objective. Why is that a big deal anyway? Exactly, if the criteria was objective, then the SEC's internal deliberations would be useless. Is XRP a security? And what did Brad Garlinghouse know about it when he sold it? The SEC was far from reaching a consensus on what constitutes a security or not in the new asset class before the XRP Army came to the rescue. Statements and videos on the agency's website express concerns about Ethereum and XRP between the years 2017 and 2020. As an example, the XRP community just uncovered a video that we captured and transcribed. The judge seems to have seen these recordings before. If the SEC commissioners were having lunch and discussing their doubts as to whether or not XRP were securities, that information would be pertinent. That someone said was the high point of the hearing in Mr. Hogan's eyes. All right, I'll own up to it. Lawyer for Ripple Matt Solomon used the No VAC Cakes Act case to argue that the claimed breach could not have been so evident that the defendant must have been aware of it. According to Jeremy Hogan, the judge agrees that the paper's significance is enough to refute the SEC's claim of privilege. This has prompted her to ask for a review behind closed doors. The SEC will provide Ripple with lightly redacted versions of the privileged documents while providing the judge with full, undeleted copies of all documents, so that she can make a determination on the subject of privilege. In the meantime, Ripple has filed a motion to compel the SEC to provide clear answers to queries about the applicability of the Hawaii test to XRP. The plaintiff has been evading the defendant's questioning and sometimes contradicting their own statements. Judge Sarah Netburn has scheduled a telephone conference for today to try to settle the privilege disagreement, which has been going on since April. SEC officials have said that discussions within the agency about the characteristics of XRP and Ethereum are shielded by the DPP or deliberative process privilege. This has been shot down twice by the judge, who believes those documents are crucial to Ripple's fair notice defense. Today's hearing could end up being a huge win for Ripple. The defendants argue that the SEC failed to provide adequate warning that XRP could be considered a security because internal records will show that the agency's decision-making has been inconsistent throughout the years. Published testimony from William Heinemann has already created the widespread perception that regulatory clarity is lacking in SEC communications. Jeremy Hogan, a lawyer well-liked in the XRP community, has found two bombshells in that deposition that could strengthen the fair notice defense. An SEC request for Ripple to provide over meeting recordings was filed yesterday. According to the complaint, Ripple was aware that it routinely filmed staff meetings but never told the SEC of this fact until a key former employee testified in her deposition earlier this month. In an official letter, Judge Sarah Netburn warned that anyone caught making illegal recordings could face criminal charges. John Deaton has invited as many people as the conference call will allow. An application to intervene in the SEC and Ripple lawsuit was filed by counsel for around 20,000 XRP investors. The maximum number of attendees is capped at 4,000. The SEC has previously made public expressions of satisfaction with the level of participation in these sessions. Judge Netburn's court conferences have been significantly disrupted by the thousands of investors who have shown an interest in this litigation. John Deaton suggested that they have as many people as possible on the conference call, but give them nothing to complain about. Holders stuck to their word and packed the conference call to the maximum amount, as requested by lawyer John Deaton, demonstrating the suit's relevance for the digital asset market. The judge has reminded everyone that recording or broadcasting court proceedings is against the law and carries criminal penalties. Initially, Judge Sarah Netburn questioned if counsel Matt Solomon's knowledge that XRP was a security in 2013 was objective, to which garlinghouse replied that it had to be clear to a reasonable person. This inquiry pertained to the SEC's famed aid and abet allegations in its complaint against the named defendants. Legal counsel for Ripple argued that even if XRP's status had been clear to the SERP's status had been cleared to the SEC before the action was filed, Mr. Garlinghouse still would not have known. Matt Solomon brought up the deliberative privilege process, DPP defense that the SEC had used to keep its internal record from being disclosed to the defendants. Mr. Solomon said that the plaintiff had acted excessively with respect to DPP and that he should be compelled to give Ripple with those documents. The court was unsatisfied with the attorney for SEC, George Tenreiro, and his nuanced reading of the SEC. So he turned to Tenreiro and asked about the reckless level for the plaintiff's claim of aiding and abetting. Mr. Tenreiro first attacked Ripple's analysis, arguing that only clear and concise information is valuable. Was Mr. Garlinghouse's behavior objectively reasonable? The judge asked he might testify either that he did or did not know before a jury. Was the sex arbitrary reaction? But that's subjective. The court interrupted the SAC in response to the judge's inquiry. Mr. Tenreiro repeated his earlier statement that he had not given a fair assessment of Garlinghouse's alleged complicity in the offer of an unregistered security. The attorney for the SAC then voiced some worry. A very harmful effect was that Ripple's desire to simplify everything into digital asset legislation, conduct an internal audit of everything, and throw open the door. The judge would like to see the confidential paperwork for herself. Judge Netburn questioned whether or not it was necessary to put a time frame on the ongoing discussions. Mr. Tenreiro claims that the privilege logs contain several examples of pre-decisional and post-decisional operations. The judge cut in, "What makes you think I already know all that?" After the judge decided to see the SEC documents in private, Mr. Tenreiro warned that the proceeding could become very biased. The internal records will not be examined by the defendants to make a decision on the SEC's deliberative process privilege claim after September 28. As Judge Netburn reminded the SEC during the in-camera review, the judge will continue by independently analyzing the SEC's internal records. For the time being, that's all there is for now. We appreciate it and hope to see you again soon.